Professor Mark Grabowski. In this video lecture, we'll discuss Internet law. Believe it or not, the Internet does have laws. Although the Internet may sometimes seem like the old Wild West where anything goes, there are actually a number of legal issues that can arise. First, you should know that the Internet is protected by the First Amendment. If you're using the Internet in America, that is. If you're using the Internet in some other countries, you may find that some of your favorite websites, such as Facebook, TheNewYorkTimes.com, and Google, are blocked due to government censorship. But Americans enjoy great freedom online. In the groundbreaking 1997 Supreme Court case, Reno versus American Civil Liberties Union, the United States Supreme Court ruled that the Internet has as much First Amendment protection as the traditional media. But just as there are freedom of speech and freedom of press rights online, there are also things that can get you in trouble online. For example, libel laws apply to online media. You can potentially defame someone with a tweet or even a Snapchat. As with the analog world, or traditional media, offensive speech, including hate speech, is protected by the First Amendment. But fighting words are not. What this means is that some forms of cyberbullying are legal, and some forms are not. If you threaten someone online, you could be arrested. But if you merely insult them, that's not illegal because opinions are protected by the First Amendment. However, there could be social consequences. If you engage in offensive speech, people might shame you on social media, your school might expel you, or your company might fire you. Remember, the First Amendment only prevents the government from restricting your speech. It does not apply to private organizations or individuals. You must also be careful about avoiding copyright infringement. Just because it's easy to go on Google and find virtually any image, that doesn't mean you necessarily can copy it and use it without the image owner's permission. Similarly, if you download a movie from BitTorrent or some other website, you could face steep fines for copyright infringement. In addition to web users, web developers must also be careful. If you create an app or website for the purpose of enabling others to steal copyrighted material, such as music and movies, you could face legal punishment for what's known as contributory infringement or vicarious infringement. This is what led to the downfall of video sharing site Mega Upload and the original version of Napster. In severe cases, copyright infringers may face jail time in addition to heavy fines. You might be wondering, well, why don't websites like YouTube get in trouble for copyright infringement? In 1998, Congress created the Federal Digital Millennium Copyright Act, which provides a limited safe harbor allowing publishers or websites to escape liability for copyright infringement if they promptly pull down infringing material posted by users after receiving notice of the infringement. So the burden's on the music and TV and Hollywood studios to notify YouTube that they have a copyrighted video on their website, and then YouTube has a certain amount of time to take it down. If YouTube did not take down the video, then they could face trouble for contributory or vicarious infringement. So in summary, laws pertaining to copyright and libel and fighting words also apply to the Internet. These are just a few of the many kinds of laws America has related to the Internet. But often our Internet laws are insufficient. The law invariably lags behind technology, and many American media laws have not kept up with the latest problems posed by technology. For example, our privacy laws haven't been substantively updated in more than 30 years. Since 1986, technology has advanced at a breakneck speed, making privacy laws governing it grossly outdated and out of touch with how people use, store, and share information nowadays. Congress has been unable to pass even the most uncontroversial proposals, let alone comprehensive reforms. For example, in 2012, the House of Representatives blocked a proposed federal law that would have prevented employers from demanding job applicants' Facebook and other social media passwords. In 2016, the Senate failed to agree on the proposed Email Privacy Act, which would have required law enforcement to get a warrant before accessing Americans' emails and other electronic communication. Meanwhile, the Supreme Court is embarrassingly behind the times on technology and has been reluctant to interpret how our laws, some of which were created 200 years ago, should be applied to modern-day technology. A few years ago, for example, Justice Elena Kagan revealed that most justices don't even use email. While technological advances have forced workers in many industries to retool or retire, the Supreme Court justices cannot be required to change because they enjoy lifelong appointments. Tired of waiting for the federal government to act, some states, such as California, have started implementing a series of trailblazing laws aimed at protecting internet users. While states are not allowed to restrict your constitutional rights, they can provide their residents with more rights than they have under the U.S. Constitution. So California, for example, forbids employers from asking their employees for social media passwords. They're providing their citizens with additional privacy beyond what is given to them by the federal government. Another challenge to internet regulation is in its international nature. Although the United States military is typically credited with inventing what became the internet, no one really owns or controls the internet. The internet is a multinational, borderless communications medium, so each country regulates it in a way that conforms with its political, cultural, economic, and social norms. But internet laws can vary significantly country by country, and this can lead to international conflicts because the internet is borderless and users can interact with people all over the world. For example, hate speech, as you know, is legal in America, but it is illegal in many European countries. Yahoo, Twitter, and other American companies have run into legal troubles in France because of some of the anti-Semitic content on their sites. Most Americans have Facebook accounts, but in China, Facebook is banned. In America, there's pretty much no restrictions on hyperlinking your website to another website. For example, you could have a link to an interesting website on your blog. Some countries, however, such as Australia, forbid linking to certain types of copyrighted material. So how can countries resolve these differences? In recent years, there has been a push to give the United Nations blanket authority over the internet. But such a development is unlikely to occur, given that there are nearly 200 countries and they all have their own, often conflicting ideas of how to run the internet. Think about it. Would you want the United Nations to be in charge of the internet if that meant you had to give up some of your rights as an American? Let's face it, oftentimes Americans can't even agree on what the law should be in their own country. Consider the issue of network neutrality. You've undoubtedly heard a lot in the news lately about the regulation known as network neutrality. Network neutrality, which is also sometimes referred to as net neutrality, internet neutrality, or open internet, is the principle that internet service providers and governments should treat all data on the internet equally, not discriminating or charging differentially by user, content, site, platform, application, type of attached equipment, or modes of communication. Internet service providers such as Verizon, Comcast, and AT&T oppose net neutrality regulations because they insist it will hurt investment and innovation in their industry. But consumer advocacy groups argue that net neutrality is necessary to guard against censorship and anti-competitive business practices by powerful internet service providers. There has been extensive debate over whether net neutrality should be required by law in the United States. And in recent years, lawmakers and courts have flip-flopped on this issue. It's likely that network neutrality will continue to be a controversial issue in America for years to come. Well, I could go on and on about internet law. There's so much to cover that I actually teach an entire semester-long course entirely dedicated to internet law. But the purpose of this video lecture is just to provide an overview of some of the important and common issues related to regulating the internet in America. So this is all we have time for today. Hope you enjoyed watching and contact me if you have any questions.